All right, it's 8:01, so I think we're going to get started today. Welcome everybody to the latest installment of Schoeneck King's monthly School District 101 webinar. I'm joined today by my law partner, Ayanna Thomas, and today we're going to be providing kind of a 101 update and reminder about election law. I don't know about all of you, but Ayanna and I were just joking when we were preparing for this presentation that election law and school elections are kind of one of those things that we all develop amnesia about because we don't have to work with it for about 10 months out of 12 months of the year. And then we have to all refresh our recollection as we approach election season. So we thought it would be helpful as part of Bond's webinar series to include just updates and overview and to refresh all of your memories about how school elections work as you're heading into this election cycle. As I said, we offer this webinar series on a monthly basis on the third Thursday of every month. It is offered at 8 a.m. exclusively for Schoeneck King School Law clients. And we've had a lot of questions from many of our clients saying, can we have multiple individuals in our organization attend the webinar? That is certainly permissible. So if you have any trouble getting any of your folks signed up for our webinars, feel free to reach out to either myself or Ayanna or anybody, any other teammates at Schoeneck King that you work with, and we'll make sure that all of your team members can get signed up for our professional development opportunities. So we're going to do today's presentation in a little bit of a question-answer format. Ayanna and I are going to pose questions and then provide answers and discussion. We're going to alternate and then hopefully leave a few minutes at the end of the presentation for any of your burning questions as well. Again, election law and school election law in particular is fairly hyper technical. So there may be a situation where if you ask a question on the screen, we may still say that Ayanna and I will follow up with you individually on that question versus answering it for the whole group if there's specifics that are involved in your situation. But we'll try to provide some real-time Q&A support and answering your burning questions as well. So without further ado, we're going to get started with our presentation. And Ayanna, do you want to take over our first question and get us started today?
Sure. Actually, Kate, I'm going to go to the second question because I really want to address military ballots. That's been a lot of time going over that.
You go right ahead then. That is your prerogative. Kathy, can you advance the slide, please?
I'm sorry, Kate, you can start with question 1 and I'll do question 2. So
okay, there we go.
So,
all right, great. Clearly, I have not had enough coffee this morning, so I'm going to rely on Ayanna to keep me organized. But so our first question we have this morning is, if a person is not sick but has a fear of contracting or being exposed to COVID-19, may that person receive an absentee ballot for the May 2023 election? Can you please advance the slide? And the answer is yes. And those of you who've been following school election developments through the pandemic will recall that originally this was the subject of an executive order just after the pandemic began. Essentially, the very first election, which was the 2020 election, the governor made the entirety of the school election an absentee ballot process. Then that process was only in place for 2020. In 2021 and 2022, the legislative solution that was developed was that essentially fear of developing or contracting a disease is now a sufficient ground to obtain an absentee ballot. Previously, that was not the case. Previously, you had to actually have contracted a communicable disease in order to obtain a ballot. So we had reported when we did a similar presentation last year that that solution was only in place for 2022. It was extended through December 31st, 2023, which means that that provision will be in place for the annual meeting in May. And the other point that we would want to make as well is that this will likely result in some changes to your template annual meeting notice. As you know, you're required to include disclosures regarding how and when voters can obtain absentee ballots in your annual meeting notice. So we do recommend including language regarding the availability of absentee ballots due to the fear of contracting communicable disease as well in your annual meeting notice. Next slide, please. Ayanna, you want to take question 2?
Yeah, so question number 2, can you please confirm the number of trained election inspectors required for election / budget vote? And this is a very important question because it's something we addressed and it came up in a commissioner's decision. So for non-city school districts, there must be at least 2 election inspectors per ballot box or voting machine. So that means that if you have 2 voting machines, so you need 4 election inspectors. Also, there must be a chief election inspector as well at each voting site. And if the district's divided into separate election districts, that means there should be at least a chief election inspector at each election district, and the chief election inspector must also be appointed by Board of Education. Now, differently for small city school districts, the Board of Education must appoint 3 election inspectors for each election district. So that means, so for example, if there's 2 voting machines, you will need 6 election inspectors. Next slide, please.
Our next question is regarding whether a person needs to be a registered voter in order to properly sign a nominating petition. And this, the intent of this Q&A is to illustrate the distinction in the law regarding qualified voters versus registered voters. So in many districts in New York State, the registration of voters prior to the election is required. I know one of the things that's great about our practice is that we have the privilege and the fortune of representing school districts around the state. So we get kind of the whole statewide perspective on this. And what we've experienced is that voter registration is something that's pretty ubiquitous, pretty common downstate, and less common in upstate and central New York. We have a lot of districts still up here that do not use a system of personal registration, but instead have poll registration. The reason I'm getting into that distinction, and we'll hit some of our other questions hit on this as well, is that a question often comes up regarding who is qualified to actually put their signature on a nominating petition. And the answer is that although you need to be a qualified voter of the district, you do not need to actually be registered in those districts that require personal registration. You can simply be qualified, which means being a citizen, at least 18 years old, a resident for at least 30 days immediately preceding the meeting, and then likewise not having any prohibited statutory conflict with voting. So registration is not required. However, being a qualified voter is. Tangentially related to this, and then I'll turn it to Ayanna just to see if you have any war stories or other anecdotes to add as well. But I want to take a moment to pause here regarding the registration question as well. We get questions all the time regarding how and when and where people can carry nominating petitions and obtain signatures for nominating petitions. So I've received the question, for instance, of can I have multiple individuals carry petition sheets for me and obtain signatures? Or do I have to personally witness every person that signs my nominating petition? There's no requirement in the law of a witnessing process, and there is no requirement that signatures on a nominating petition be notarized or verified or anything else. There was actually a commissioner's decision from the 2008-2009 time period in which the commissioner actually held that it was improper for a school district to refuse to accept a nominating petition simply because the signatures were not notarized and because the candidate did not notarize their own signature. So similarly, we get questions around, in order to ensure that a candidate is a properly qualified school board candidate, can we have them notarize or sign off that they've read the requirements or understand the requirements? We generally advise against this because, again, that's not required in the law. The requirements for what need to be in a nominating petition are very clearly set forth in the law. In the case of small city school districts, all that's required is the name of the candidate, their address, and the 100 signatures. In the case of central, union-free, and other school districts that are not small city school districts, the requirement of the signatures is different. It's a fixed number or a percentage of the prior year's voters. However, also, there is no requirement of notarization, and the law does not require that any signatures on that petition be notarized. Before we move off that topic in terms of who and how people can sign nominating petitions, Ayanna, did you have anything to add here?
Yes, just one thing. Sometimes it has come up where someone would say that I believe that this person is not a qualified voter and they signed a nominating petition. And that's something that's pretty easy to check, especially in central and union free school districts, where I know some of the districts have a system called BOLD, where they can check to see who is a registered voter and just check and verify the person's name and address to see whether they're a registered voter. So although only qualified voters are required for nominating petitions, but some people may be registered already, so you can verify whether they're actually a qualified voter or not.
Yep, and that raises another somewhat related issue too, which relates to whose job is it to determine whether somebody who is submitting a nominating petition is actually qualified to be a school board member. And the law is actually not crystal clear in that regard. We have some legislative history related to the provisions in the Small City School District Act that make it pretty clear that the legislature intended that the Board of Education would be involved in rejecting or accepting nominating petitions, and that the district clerk's role should really be limited to the clerical task of reviewing to confirm that the signatures are present and that the other clerical requirements for the nominating petition are satisfied. So what that means is that when we receive calls, typically, and it's not this early, typically it's later in the election cycle as we approach the nominating petition deadlines. But as those deadlines approach, it is not uncommon that we will receive questions from clients regarding, such and such has submitted a nominating petition, but I happen to know that she only bought her house in the district, for instance, 3 months ago, and she hasn't satisfied the 1-year minimum residency requirement. Or conversely, what often comes up is a board member will call me and say such and such has submitted a nominating petition, but I know that their house is not within the boundaries of the school district. Therefore, they're not a resident. What do we do about this? And typically what we recommend is that the board clerk accept the nominating petition, but then present it to the Board of Education with an expression of the concerns that are involved. That is not required in every case. I've also had the question of, are we obligated to verify the residency of, every individual who submits a nominating petition? There's nothing under the law that compels that. However, if concerns are raised, we recommend that the board do conduct an investigation and review, because if you do not, you can end up in a situation where you have someone on the ballot who ultimately is not qualified to take an oath of office and not qualified to actually take the seat that they're given, which can raise, a potential for election challenges, hurt feelings at the very least, and confusion. So generally speaking, this issue regarding qualifications is something that the Board of Education should take seriously if concerns are presented to their attention. We were unable to find similar legislative authority in the context of union-free and central school districts, but we've typically advised similarly that the board clerk play a clerical role and ultimately turn over the matter to the Board of Education for review and investigation if concerns are expressed. Next slide, please.
Okay, my favorite topic.
Yay, military ballot. Brianna loves
military ballot. I would say it's the most confusing part of the law, but I think the most important piece here is to remember the dates, and I was going to just hit on a couple of the main important dates dealing with military ballots. So the question number 4, it says, can completed military ballots be accepted by email as a deadline 5 p.m. on election day? So before I answer the question, I'm going to just preface it with this. So for military voters, qualified military voters, they can either request that their military ballot application, and military registration application be sent to them by email, by fax, or by mail. However, when it comes to returning the military ballot, it must be received either by mail or personally delivered to the office of district clerk by 5 p.m. election day. So I know also sometimes there's confusion. What does the 5 p.m. deadline mean? Does it mean it has to be filed by 5 p.m.? Does it mean it has to be posted by 5 p.m.? It must be in the hands of the district clerk by 5 p.m. on election day. So also I mentioned before about some key dates regarding military ballots. So for city school districts, the district clerk must mail out all ballots no later than 14 days before the election. So that'll be May 2nd, 2023. For non-city school districts, the ballots must go out and be mailed out to all military voters by April 21st, 2023. Also, April 20th, 2023 for non-city school districts is a deadline to submit ballot applications. Also for non-city school districts, also another important deadline by April 18th, 2023. That's when the candidates' names must be formulated. Also, the propositions or any referenda must be figured out. That is in time for the military ballots to be mailed out to military voters. So I understand we're going to talk about this later about when is the time where the public hearing must be held for budget votes and what the deadline is. But unfortunately, the military ballots deadline really impacts the deadline of when the board must approve their budget. So for non-city school districts, by April 18th, the board must figure out what are the propositions, what are the referenda that's going to go on the ballot, and also what are the candidate names.
And one thing I will add, that's a great point, Ayana, about how the deadline for military ballots, when the legislature enacted that initiative, it really pushed back a lot of the timelines, to Ayana's point, because the ballot needs to be finalized in order to then submit that ballot to military voters via the military ballot process. A question has arisen frequently regarding, because those ballots go out so early, what happens if the ballot subsequently changes? Let's say you have a candidate who is deceased, a candidate who withdraws, a candidate who's deemed ineligible, whatever the case may be. And suddenly those military ballots that you transmitted in March are no longer actually accurate in terms of what's going to the voters in May. And that's actually addressed by regulation. The military ballot regulations state that if the ballot subsequently changes and the ballot cannot be canvassed, it should merely be set aside. It's simply not canvassed. Now, if you get a military ballot, let's say that has a vote on various propositions on it, and that also contains votes for candidates, and let's say the candidates change between the time that that military ballot is issued and when it's returned to you, you would discount the votes for the candidates. In other words, you would simply not canvass those votes, but you would count the votes for the propositions, because of some other provisions in the education law that state that where certain votes on a ballot can be discerned and others cannot, you still credit those that can be discerned. So that comes up often because the deadlines are so early. I know last year we had numerous clients that had issues with a lack of conformance between the military ballot and the candidates that ultimately ended up on the ballot. I also want to note that this whole issue with military ballots and acceptance by email, it relates to a related issue, which I don't think we have a slide about, but I want to touch on it. And Ayana, feel free to jump in as well, which is the concept of whether nominating petitions can be submitted by email or whether absentee ballots can be submitted by email or fax. And we've generally advised against this. The reason being that in the case of military ballots, the legislature was really clear that the application could be submitted by facsimile or email, but that the ballot itself must be returned in hard copy per Ayana's guidance. Because the legislature was clear regarding the methods of transmission of email and facsimile in the military ballot situation, we've by analogy said that in other instances where that authority does not exist, we recommend against accepting formal documents by email. So although it may be tempting to accept nominating petitions by email, we generally advise against that. Email also presents some problematic chain of custody issues, which we've had in several of our, we're fortunate, Ayana and I represent several districts that have had lots and lots of election challenges. So we've seen the worst case scenario, the best case scenario, and pretty much everything in between. But in districts that are very litigious, this is certainly a concern, that there's a chain of custody issue when you accept emailed nominating petitions, which is, what happens if that email goes into the district clerk's spam folder? What happens if the person claims that they transmitted it, but it was not received? There's all kinds of issues that come up that make that counsel against accepting electronic nominating petitions and sticking to the traditional means until the legislature makes an adjustment in that regard. Anything else that you want to add on that, Ayana?
Yes, that's a good point, because also I remember we had a question about whether electronic signatures are accepted for nominating petitions, and also we've advised that it should be a handwritten signature for nominating petitions as well, because of military ballots.
Mm-hmm. Great. Next slide, please. So this question relates to residency, and it's if a person owns a home in the district, are they considered a resident of the district who is eligible to be elected to the school board? And the related question would be eligible to even vote in the election. And the answer here is this is a trick question, not necessarily, because merely owning property in a district is not sufficient to establish residency. The test that is used for residency for voters and for school board candidates is actually the same test for residency that's been developed for students. And you're all probably familiar with that residency has been defined by the commissioner and by our Court of Appeals as a physical presence plus an intent to remain. The intent to remain can be conceptualized as basically, where do you plan to make your home? Where do you lay your head, and where is the place that you intend to make your home? That same rule applies to school board elections as well. If you want to run for the school board, you have to actually not only own property in the district, but that needs to be the place where you intend to remain and make your permanent home. Similar to if you want to vote in the school board election. The only differences are that in order to run for the election, the period of time for residency has to be a continuous and uninterrupted period of at least 1 year, whereas it's only 30 days to vote. Any other points on residency, Ayana?
I think you covered all of them, Kate.
Yeah, and this goes back to, again, the point we were making earlier that the place where we see residency concerns come up typically is either when nominating petitions are first submitted and concerns are raised regarding either the individual who's being nominated or the people who've actually signed the nominating petition. That's a place where this issue is raised. And again, our recommendation is that the board intervene and conduct an investigation to determine residency in that situation. It's also come up in some of our districts. It comes up after the election, or during the election, which is a real bear as well. There's provisions in the education law regarding what you're supposed to do if a candidate drops out of the election, according to certain timelines leading up to the election day. However, if the district determines the day of the election or even after the election that a person who is on the ballot is ineligible to actually be a school board member, there is not a lot of authority in the law regarding how that situation is to be handled. And there's certainly a high risk of an election challenge or litigation because you're going to have somebody that's not happy in that situation. Ayana, you look like you had something to add to.
Oh, no, I'm okay.
Oh, you're good. Okay. Next slide, Kathy.
All right, question number 6 is also another very popular question that comes up almost year to year. Yes, year to year. So is the school board member allowed to advocate for the budget? So yes, they can advocate for the budget in their own individual capacity. But we always caution board members for advocating for the budget or expressing their interest on social media. It's typically that's the forum where a board member would like to advocate for the budget. Board members have to be very careful. One, not to show that they're making a statement on behalf of the board or give the impression that making a statement on behalf of the board. Also, they should use their own resources to advocate for a proposed budget or any other propositions. And they cannot use district funds, facilities, or channels of communication to advocate for the budget or advocate for other propositions. Also, so I mentioned social media. So there we had a situation where a board member wanted to talk about the budget or put a post up on their page regarding the budget or propositions, but the profile clearly indicated that the person was a board member. So it said like board member of this particular school district. And we cautioned that board member said, just by identifying yourself as a board member on your profile page, you may give the impression that you're making a statement on behalf of the board. So a good, if someone still insists on writing a statement, you want to clarify, maybe give a caveat and say like, by the way, this is my me speaking in my individual capacity as a citizen within a district. This way it's clear that the statement is made on that person's behalf and not made on behalf of the board.
And the basis for that too, I just want to make sure everyone's clear on that. The reason for that is because the courts have recognized a constitutional prohibition on the use of school district resources or funds to promote a budget vote or to promote a candidate for school board election. So the distinction is always, if you're doing it in your private time with your private resources in your personal capacity, that's okay. If you doing it in your official capacity or utilizing any district channel of communication or property to affect that message, that is where the problem becomes, and that's the Phillips v. Maurer line of cases. Where this often comes up is the captive audience concept as well, which I'd like to touch on, and Ayana may have some more stories in this regard as well, but usually most of our school clients are well versed in this rule and are aware that they can't, school board members cannot in their official capacity advocate for the budget. The thing that comes up more frequently though is the question about, can we get a get out the vote message? Can we generally encourage people to vote? Can we generally disseminate information about candidates, about the propositions? And the answer to that is a qualified yes, which is that, so keep in mind that the commissioner has issued several decisions that say that generally speaking, you should avoid a get out the vote message if that message is only being sent to a captive audience or a group of people, in other words, that are already predisposed to support the school district and vote for your budget. So what would be potentially problematic is if you send out a get out the vote just to the boosters or just to your parent listserv, for instance, because parents who have children enrolled in the district are more likely to vote for your budget and to support your budget than those who do not have children in the school district. So although it's unlikely that the commissioner would set aside an election on that basis, the commissioner has certainly chastised school districts for sending messages only to certain portions of the population, if it could be construed that they're picking a portion of the population that is more likely to support the budget. So that's the more common situation. I think Ayana is right that the real nuisance now is social media with all of this, because many board members interact with social media, both in their official capacity with their board member hats on, and as private individuals. You all had lives before you became board members. Presumably you'll have lives after you're done with your board service. I make no promises, but I assume that will be the case, that you'll be able to get good, full personal lives and not be stuck with board service your whole lives. But when the point that needs to be considered is that when you are wearing both hats, you always need to be mindful about, if we're using any sort of channel of communication to advance this message that's a school board channel, that could run afoul of Phillips v. Maurer. So, Ayana touched on this, but what we often recommend is if you're posting on social media or you're sending a letter to the editor or something like that, always just use a conspicuous disclaimer. Include in your letter, I'm writing this in my personal capacity, and it expresses my personal views, not the views of the blank school district board of education. If you're the president or the vice president of the board, I just think it's generally a good strategy because, again, it avoids any confusion. It avoids any confusion regarding what role you're playing or what hat you're wearing when you're making those comments. Next slide, please.
I'm sorry, Kate, I just want to add one point.
Oh, go right ahead.
Something. Typically, we will review. Sometimes just we'll like to have a get out the vote video or a blast to go out to all residents, and we typically will review it to make sure that there's no persuasive language, where there's no language showing that the district is advocating for the budget. So we're happy to review that. Also, it's important in those videos, sometimes they will include teachers and other staff members that you don't want to say, you should vote for the budget, you should do this, just generally say that, at the school district election, that's where the vote will be held. So you want to give general language, just factual information about what the propositions are, the budget, and that's it. But don't want to give any language showing you're advocating for the budget or you're persuading someone to vote in favor of the budget.
And it's a delicate balance because school districts have an obligation to inform their population and educate their population about the budget, and at the same time not advocate for the budget. So that's always a delicate balance. Like Ayana said, there's often a fine line between what is factual versus what is persuasive. We are always happy, of course, to review your communications. If you have any question about that or want a second set of eyes on it, sometimes that's helpful. The next slide we have is just about the time of and the nomenclature or the language that's used. We often get confused looks when we say, can we review your annual meeting notice? We tend to think of meetings as being board meetings, but in the education law, annual meeting actually has a legal meaning, which is it is that third Tuesday of May in which the population of your district comes and votes on candidates and on propositions and on the budget. So when we use the term annual meeting, that's a synonym for annual district election, essentially. And it always takes place at the same time, with the exception of certain limited circumstances in which the Commissioner of Education is able to order an alternative date. Keep in mind, when the education law says board meeting, that typically means a meeting of the members of the Board of Education or the trustees of the board. When it says annual meeting or district meeting, that typically refers to the voters actually meeting and voting on things. So just a note on the language, as that can sometimes be confusing, I think. Anything to add there, Ayana?
Not sure everyone knows this, but this year's annual meeting is May 16th.
Yay. Next slide, please. So time of the annual meeting, do you want to take this one, Ayana?
Sure. So the time of the annual meeting, so for school districts that will conduct their vote by voice vote or show of hands, the meeting must be held at 7:30 p.m. plus different times been set by vote at a previous meeting by the voters. In other school districts, other than small city school districts, because small city schools have their own set of rules that they have to follow, polls must be open for at least 6 consecutive hours starting at 6 a.m. and include at least 2 hours after 6 p.m. So I know some districts typically close their polls around 9 o'clock. And in small city school districts, the polls must be open for at least 9 consecutive hours starting after 7 a.m. and including at least 2 hours after 6 p.m. Next slide.
So this is an important just general reminder that, that is worth noting, but as a general matter, New York State election law does not govern school elections. And I will say 90% of the inquiries that you will get from taxpayers and members of your population about the school election are based on the fact that our general population doesn't necessarily appreciate this distinction. We have a state election law. That state election law controls almost all elections that take place in New York State, with the exception of school board elections, which are governed by the education law. And that is because both as a matter of statute in the education law and as a matter of case law, it's been determined that the education law actually supersedes the election law when it comes to school elections. So the only exception to that rule is that if the school election law is silent and there are provisions generally applicable in the election law, those provisions may be applicable in school elections as well. But it's important to never assume that a provision that controls the general election is also going to be in play in a school board election. A lot of the confusion, I think, around the contents of ballots comes from this, because you work with the County Board of Elections, of course, to help prepare your ballots and to prepare your voting machines and all of that. The County Board of Elections is taking their guidance from the election law typically in how your ballots are set up. I will say the greatest area where there can be confusion here is in small city school districts, where you are required to divide into election districts and have a system of personal registration. There are some distinctions between what goes on a ballot machine ballot in a small city school district versus what goes on the general election for cities, generally speaking, in city elections. So I would just say, when in doubt, check with your favorite bond attorney about that, to actually review the ballot as well, in addition to your annual notice and your absentee ballots and such, because there are some fine distinctions in terms of how the ballot's supposed to be set up in small city school districts as well. Next slide, please.
And also, in addition to ballots, also the oath envelope as well. So in election law, they have their own instructions on what an oath envelope should look like and what information should be included on the envelope, and it's different from what is in the education law.
Yeah, and actually, Ayana loves military ballots, but she forgot to note this, that the attestation that's required on the envelope for military ballots has some fine distinctions as compared to the attestation that's required for absentee ballots. So make sure as you're preparing those envelopes, again, that you're making sure that you differentiate between those two oaths as well. There is different language that's required. I don't know why they don't make it all the same. That would make our lives all a lot easier, but apparently our legislature likes making work for school attorneys. So there are some slight variations in the attestation. Do be mindful of that. Anything else you want to add, Ayana?
I think we covered all, Kate.
Great. Next slide, please.
Yes. Oh, wait, sorry, we didn't touch base on this slide. So the Commissioner of Education has exclusive and final authority over election disputes. And there's a standard that's applicable for what a commissioner would overturn an election or not. So typically when there's technical irregularities, the Commissioner of Education do not overturn an election. However, there's a strong showing can be made that the outcome actually would have been different, but for the irregularity, and that's when the commissioner would overturn the election. And the next couple of slides talk about a case where the commissioner actually did overturn an election due to significant irregularities.
But the whole reason we're going to share that case study with you is to illustrate just how terrible your election needs to be in order for the commissioner to set it aside. It's not something that happens every day. It is not something that happens based on technical irregularities. Like Ayana said, there has to be a demonstration that either the will of the voters cannot be discerned from the voting pattern that exists, or that the outcome of the election actually would have been different, but for this procedural oversight. So it's not sufficient to simply allege that there was a procedural oversight or that a provision in the education law was not followed. There has to be actual, real, concrete harm that results to the election process as a result of the oversight. Next slide, please. So again, like we said, although it's rare, we want to give you an example of what not to do in a election decision and the appeal of Lanzalota, which did result in an election being set aside. So petitioner runs for a seat on the school board, ends up losing by 10 votes. And the allegations from the petitioner were that there were an insufficient number of election inspectors appointed for each voting machine. And also that essentially election inspectors were being removed to address certain situations that were rising during the election. And as a result, they were leaving the polling places even less attended than they should have been. So there was a concern regarding the number of election inspectors and supervision of the poll boxes. Next slide, please. Now, one of the issues that also came up in this case was the requirement regarding canvassing of absentee ballots. You all probably remember this during the 2020 election when we all became way more focused on absentee ballots than we ever thought we would be. But do recall that the education law is clear in 2018-A that in districts with personal registration, absentee ballots must be opened by the election inspectors after the polls close. And there has to be a challenge procedure. So that's the whole reason why they're opened in public is so a member of the public can observe a public opening of the actual ballots. So in the Lanzalota case, another deficiency that was raised by the petitioners was that the ballots had been opened in the presence of election inspectors, but not in the presence of the public. So there'd been no opportunity for a public challenge to the validity of the ballots. Next slide, please. Additional issues. There were 25 paper ballots cast, but they were not reflected in the district's election results. So this is another place where there's a ripeness for an election challenge and an opportunity for an election challenge, which is where you have certain aspects of your tabulation that are not computing properly. So for instance, you have evidence that a certain number of people voted in your voting machine, but the voting machine only tabulated a lesser number of votes. Or that you have evidence that a certain number of absentee ballots were submitted, but only a certain number were canvassed. When there is a disparity between the number of ballots submitted and the number of ballots canvassed and the votes that are obtained, that's typically where an unsuccessful candidate will then advance an election challenge to say, it's impossible to discern whether or not I would have won or should have won. Recall that the difference in this election in Lanzalota was very close. There was only a 10-vote difference. So the fact that there's 25 ballots cast that were not reflected in any part of the tabulation or certification of the vote takes on a more significant meaning. If you have an election in which there's a 200 vote disparity between two candidates and there's 25 ballots that aren't accounted for, in all likelihood, the commissioner is going to say, maybe there was a technical irregularity, but even if we credited all those 25 votes to the losing candidate, that still wouldn't make up the difference. So it's not a basis to set aside the election. In this case, again, the difference in the delta between the candidates was a lot closer. Next slide, please. So discrepancy between the number of votes cast and the number of signature in the registrant books. Again, this is a defect that we've seen in a lot of cases that by itself typically isn't enough to set aside the election. But in this Lanzalota case, when combined with all the other procedural irregularities and technical difficulties, the commissioner had a real problem with this. So the petitioner claimed that there were 54 more votes cast than signatures that were in the actual registrant book. The district found a discrepancy of 13 or 17, both of which exceeded the margin of votes. So again, this was a 10-vote difference, very close election. So even by the district's tabulation, which was less significant than the petitioner's, 13 or 17 votes still makes a difference when you're talking about a 10-vote spread. So the commissioner noted that distinction and said that even though it's not atypical that there would be discrepancies at the end of an election, in this case, the election was tainted by several problems. Not least of all was the fact that there were votes that were unaccounted for, and the difference between the candidates was so slim with 10 votes that the will of the voters could not be ascertained. Next slide, please. So the outcome of the case was that the commissioner determined that the petitioner had met his burden of proof, meaning had entered and offered sufficient evidence to set aside the election, and the results of the school board election were annulled and the district was required to hold a new election. Sometimes the question comes up of, well, what can the commissioner do, or what would the outcome be if there is a successful election challenge? The outcome would can vary, and the commissioners offered various forms of relief to address election challenges. Keep in mind, and we may have another slide about this, but I can't recall, so I'm going to touch on it right now, which is the concept that only the Commissioner of Education has the jurisdiction to set aside a school election, to open the ballot box and order a recount of the ballots, or to set aside an election result. So those are basically the types of remedies that the commissioner may order if this type of pervasive lack of compliance is present. She may say, reopen the ballot box and recount the ballots, which again is something that you as a school district cannot do unless the commissioner authorizes it. Once you've certified or declared the result of your election, that declaration is permanent. You cannot reopen the box and count ballots. So the commissioner could order a recount. She could also order that the election results simply be set aside, and that the district go back to the voters and essentially redo their election, which is what was ordered in Lanzalota, because there was no way that a more simple solution was going to address the pervasive errors and problems in that election. Anything to add there, Ayana?
So I want to talk more about the next slide about absentee ballots, but since we're getting there now, one thing was noted in that decision that the absentee ballots must be counted in public. I think it's good practice as the election inspectors are counting the ballots. They should announce the winning candidates and also announce the results of the propositions, announce the results of the budget as well aloud. This way, there won't be any contest that the voting was not done in public. Also, it's good practice. I know some districts do this already. As they're reviewing absentee ballots, they will have a poll registration book and just scan the barcode associated with the name of the voter in the registrant book to make sure they didn't vote twice. Because sometimes there's people who are sneaky and they'll double vote. So to make sure they didn't double vote, meaning that they didn't vote by absentee ballot and also voted in person by voting machine. So to make sure to do that as well. And also I understand this happens a lot where it's late at night. It's 9 o'clock. Election inspectors have been there all day, starting at 6 a.m. and they're tired. But sometimes they just get voluminous amounts of absentee ballots, sometimes hundreds, sometimes or more than that. So really just look through them very carefully and making sure that there's no overvotes, which is what the next case discusses. Make sure that the ballot envelope is actually signed by the voter as well. Make sure those things are looked at before actually opening the ballot and counting the votes.
Okay, next slide, please. So lessons learned from the Lanzalota case, again, because decisions setting aside elections are really quite rare. There's hundreds and hundreds of election decisions and very few where the commissioner ordered a new election. But that said, this case really illustrates that there's a number of takeaway points here. Where there is a high risk of an election challenge, successful election challenge, where we would advise additional due diligence and making sure you have the proper number of election inspectors. Again, to Ayana's point, opening those absentee ballots in public, making sure that your paper ballot results are tabulated as part of the election results, making sure that each individual signs in prior to voting. And again, the point that we're making here is that typically a mistake or two in procedural compliance is not going to be enough to result in an election challenge. But it can be if those errors are cumulative or if they really get to the heart of the election challenge. I want to share another case study as well. Under that last point, it says typos may impact the budget. Typically, a typo is going to be in the category of something that the commissioner is going to excuse and say, school elections are run by real people in the real world. As long as there's general conformance and compliance, I'm happy. That said, there are some very unique typographical errors that can have a real impact on the election. And I want to share one of them from a real case example that we handled for a district a few years back. In that situation, the proposition that was submitted to the voters for a capital referendum contained an error, a typographical error in the description of the capital reserve that the district was using to fund the project. So the district was using some funds from its own fund balance, some funds from bonding, and some funds from a capital reserve to fund a capital project. And unfortunately, the district's proposition that went to the voters referenced a 2015 capital reserve fund. Well, by the time that proposition went to the voters, the 2015 capital reserve fund no longer existed and had actually already been spent down. What the district had intended was to reference a 2018 capital reserve, which had been established in the prior budget cycle. Well, when we discovered that irregularity, the district actually went affirmatively to the commissioner to ask whether or not they could proceed with the capital work, notwithstanding that error in the proposition. The commissioner said that because the typographical error went to the heart of the proposition, that there was no way to discern the will of the voters based on that error. There was no way to discern whether the voters would have equally been supportive of withdrawal from the 2019 capital reserve versus the 2015. So ultimately, in that case, the commissioner did set aside the election and directed the district to hold a new election with a proper proposition. This may not strike you as being that big a deal, but talk to your board clerks and they'll certainly tell you an election is not a free exercise. It's definitely, there's cost associated with it, cost with paying poll inspectors and poll workers, costs with renting machines and equipment, printing ballots, all of that. So whenever we can avoid having to redo elections, that's generally a good thing. So generally speaking, typographical errors are not going to sink an election or sink your budget cycle. But again, if it is a typographical error that makes it impossible to discern the will of the voters, a different rule might apply and the commissioner could get concerned about that. Anything to add, Ayana?
I think we covered it all, Kate. And also, we apologize. I understand that it's 8:48, and I know this first page only supposed to be 40 to 45 minutes long, and I hope you all can stay here longer. But we think it's a very important topic, and Kate and I have so many war stories and experiences. We want to just share them all with you.
Yeah, so we'll try to wrap up the rest of this presentation quickly here so that we can get everybody on with their day. We really appreciate you meeting with us before the day gets busy. So next slide, please.
Okay,
so maybe we should just, do you want to just cover this one real quick, Ayana, and just talk about
Sure, I'm just going to just cover I guess I'll just cover like the main points of this case. So it's a Pale Morton. This is a case that occurred during the COVID year when every election was entirely by absentee ballot. There was two important things that were raised by petitioners here, plural. First, that the ballot included 4 write-in spaces. So one quick note that for write-in spaces should match the number of positions that are open for candidates. So say, for example, if there's only 2 seats available for board members, that means that there should only be 2 write-in spaces on the ballot. So that was one thing, that was one concern raised by petitioners, write-in spaces. The second one was that there are 2 people who canvassed votes who were not appointed as election officials. Next slide. So the petitioners sought to annul the results of the election. And the 2 things I mentioned were 1, the write-in spaces, and 2, also that there were election inspectors. There was people who were not election inspectors that were canvassing the ballots. And basically, the commissioner said that this wasn't enough to overturn the results of election. But however, another good piece from this decision is that for overvotes, so it's important. So say, for example, there's a situation which happened in this case where there was a candidate who was running for office and their name was mentioned on the ballot, and a voter actually put that same candidate's name in a write-in space. And in this case, the election inspectors basically said it was an overvote and they did not count that vote. You should still count that vote, because what the commissioner has said is that if the voter's choice of candidates was readily ascertainable, that vote should still be counted. So it was clear that if the person voted, marked off that candidate's name on the ballot, already wrote it again in the write-in space, it's clear that their intent was to vote for that person. Next slide. And also regarding the 2 individuals who held canvass votes, again, as you mentioned before, only election inspectors should be the ones counting and canvassing ballots. but the commissioner said that the error wasn't enough to overturn the election. Next slide. Okay, nominating petitions. Kate, do you want to take that? Or you want me to take that?
Yeah, I think we already covered a lot about nominating petitions, but this is just the basics that for timing, that there is a distinction between small city school districts and central and union free. In small city school districts, the nominating petitions have to be received by the district clerk no later than April 26th, which is 30 days prior, and then for all other districts, 20 days prior rather, and for all other districts, the nominating petitions must be received by the district clerk by April 17th. So then recall that you have your 45 days of publication requirement for the legal notice. So this is really where you backdate your legal notice in the 45 days typically from these deadlines. And there was another deadline question too that was asked by someone in the chat. I happen to know the person who asked the question is coming from a central school district. So just only disclaimer is the answer to this question is different for small city districts. But the person in the chat asked, what is the last day an individual can submit for a military ballot? The answer would be 26 days prior to the election, because you have to backdate through the regulations. The regulations say that the last date that you can submit an application is 5 p.m. the day before the last date that the ballot can be transmitted. The last date that the ballot can be transmitted in central school districts is 25 days prior to the election. Therefore, the latest date that an a military ballot application can be requested would be the 26 days prior to the election.
So it's April 20th.
So, you did the math in real time too. I'm not nearly skilled enough for that. Thank you, Ayana. So it's April 20th.
April 20th, yes.
26 days prior to the annual meeting and election. So that's a great question from a central school district. Next slide, please. Budget hearings have to be held 7 to 14 days before the vote. We have had questions regarding in-person versus virtual hearings. The authority for virtual budget hearings was actually only in place via executive order for a period of about 4 weeks back in the 2020 time period. After that executive order expired, and since that time, we've been recommending a return to in-person budget hearings. I think most folks are doing that anyway, so that's kind of a not a serious point, but worth noting nonetheless. We often get questions around what is a hearing versus a meeting. The law is really very imprecise about that. The concept of a hearing actually comes from a lot of other contexts, like the environmental compliance context. And generally what we say is a hearing is like a meeting, except in a board meeting, your public only has the requirement the public only has the requirement to be able to participate, and so there's a difference in that regard. But so in a hearing, the public actually has the ability to participate and have their voices heard. Contrast that with a board meeting where all they have the right to do is actually observe and observe the proceedings, not actually participate. Questions sometimes occurs too about what happens if the budget changes because the state aid runs are not ready, and we ultimately end up having a lesser or greater amount of state aid than we're predicting when we do the tax report or prepare the budget. Keep in mind that a budget is a cap on spending. It's not the minimums. It's not the minimum spending, it's the maximum spending. So if your state aid run does not end up supporting the budget that you've drafted, you would not resubmit your budget. You would not resubmit your real property tax report card. You would simply adjust accordingly, depending on how the budget run ends up. Another point that folks often forget too is that although typically spending outside of your voter-approved budget is impermissible, expenses that qualify as ordinary and contingent expenses are an exception to that rule. And the commissioner has said, and the education law also says that the expenditure of grants and aid are an exception to that rule. So you can always spend grants and aid outside of your budget for the intended purpose of the grant. Next slide, please. Ayana?
Yeah, so ballot counting, only absentee ballots that are received by the office of the clerk by 5 p.m. on election day may be counted. Again, we spoke about this before. It cannot be postmarked by that day. It must be in the physical hands of the district clerk by 5 p.m. on election day. And also, the last point here, there's been at least one commission decision that states this, that there is nothing in the law that prohibits individuals from carrying multiple absentee ballots into the polling place on the day of the election. And also another thing that is confusing, this was recently added maybe 2-3 years ago, that on the absentee ballot application, a voter can designate an agent to pick up the ballot. So it might be a case where someone say, I want to designate another person to pick up the ballot on their behalf. Next slide. Okay, so question, will districts need to...
Ayana's going to take this one because Ayana has a lot of experience with a lot of the title districts that have the Spanish speaking requirements. So tell us about your experience, Ayana.
Sure, so the question is, will districts need to print ballots and election materials in Spanish? Next slide. So yes, for districts covered by Section 203 of the Voting Rights Act of 1965, they are required to provide the language of the applicable minority group as well as the English language. And this has happened. I remember, I think Kate, you're involved with this with me as well, for many districts in Long Island, where I think OCR actually got involved with this.
Department of Justice, I believe it was DOJ. I think it was
the DOJ. Yes, DOJ got involved.
So whenever Ayana and I train, or our client, our law partner Candace joins us, one of the things that we always say when we're doing this training is, if you are subject to Section 203, you know it, because you would have been subject to a massive DOJ audit and investigation about 5 years ago that cracked down on all of the 203 districts. There's a ton of them in Westchester County and a ton of them in Long Island. You have to basically have a minimum non-English speaking population as part of your census to trigger this requirement. But if you reside in an area where the census does trigger Section 203, you are required to have any and all election materials printed in the dominant language. That includes ballots, nominating petitions, annual meeting notice, everything, all your election materials. So if you are a 203 district, chances are we already worked with you through that process because you were subject to intense scrutiny by DOJ. But if you have any question about whether 203 applies to you, feel free to reach out. The other thing I want to touch on really quickly too, and I know we are running out of time, is another accommodation issue that comes up. So this is a big one. 203 is the accommodation of non-English speakers. Keep in mind that there's federal laws, including the ADA, and some other statutory provisions in the early 2000s that require school districts to accommodate disabled voters at the polls as well. So don't be surprised. We have noticed, particularly in Long Island and Westchester, that it's not uncommon that some of the citizens concerned groups or the plaintiff groups will start just sending inquiries leading up to the election to kind of scrutinize your process for accommodating disabled voters. So all we would say is, if you get one of those reach outs where somebody contacts you and says, what is your plan to let me vote at the polls, even though I have X, Y, and Z disability, just check with us first before responding, because your gut instinct about what you have to do to accommodate that person may not be strictly compliant with the ADA, and we may be able to make some recommendations there. So there is an accommodation obligation in all districts for disabled voters. The requirement of accommodating non-English speaking voters only exists in those districts that have been designated under 203 of the Voting Rights Act. Next slide. And also under 203 of the Voting Rights Act, that includes legal notices as well. So as you all know, that the clerk has to get the legal notice published in a newspaper, and that legal notice also has to be translated in the language of a minority group. So typically it'll be Spanish, so it should be in English and Spanish. Great. And I think we've already covered the absentee ballot question, that only election inspectors can open and verify absentee ballots, e.g. the district clerk cannot. The main question that we get related to this is all the absentee ballots trickle in before the election. And every year we get at least one, sometimes several questions from district clerks saying, can I open these ballots and canvass them before the election to save some time on election day? And the answer is no, that is not a lawful canvassing process. Next slide, please. And also, it's important, you don't want to give the impression that the district clerk has looked at the ballots or try to count them in advance. So it's important to keep the ballots in a lockbox. And we could bring the lockbox to the voting site and just have the inspectors open the box, have the inspectors review the ballots, because you don't want to give the impression that the district clerk was counting the ballots in advance of the election. Next slide. We've already talked about the real property tax report card. Next slide, please. There we go. And I think we are officially out of time. So I think we're not going to have time to get through the rest of our materials. We did answer a couple of questions directly to people that asked them privately, as well as a couple of questions on the air. This presentation was recorded and is available exclusively to Schoeneck King school clients on the client portion of our website. If you have any questions about accessing the recording, do not hesitate to reach out to myself, Ayana, or Kathy Purdy, who is also on the line, and we will be able to make sure that you're connected with those resources. Of course, school elections are a complex area, much more complex than what can be covered in a 50-minute webinar. We hope that this kind of refreshed your recollection and got you thinking about school elections again as we enter the election cycle. Of course, we are ready, willing, and able to provide any support that your individual districts require as you enter the election cycle. And we're just all very honored, Ayana and I, to be your counsel and to work with you through these processes and these elections. And we thank you very much for joining us this beautiful snowy morning here, and hope everybody has a great Thursday.
Thank you, everyone.